Hello, everybody. Happy uh, Thursday, December 8th, 2022. Um, I am going to do, I think this is part 7 of my Music of the Night uh, Media Swamp Stock tutorial. uh, so, this is going to cover, I'm going to cover 3 main writings I did in 3 different tutorials. I'm just going to read them. And this is just a test. If it's not, we'll see how it goes. So the 3 main writings I've done are available at my YouTube site. Here's my YouTube site. This is the home page. You get Nicole Young, Nay Pelletier. I think I'm at HN Young, but anyway, this is my YouTube site, and this is my home page. But if you go to the About section, I'll read the description. Gays are born gay, so treating gays and non-gays alike under the law follows one of many fundamental laws of peaceful self-governing. Hitler and Goebbels were gay lovers who were not treated the same as non-gays under the law, and we all know how that turned out for everybody. All man-made calamities like slavery, wars, and holocausts were or are inside jobs created and run mostly by a very small fraction of usually closeted, highly self-loathing gay Nazis within the very cultures and communities that are being attacked. However, nothing angry gay Nazis have done or can do going forward would be possible without the help of a majority of the male population that I call affectionately, because I know and love many of them, non-gay dumbass morons. This channel gives a different take on history. On the fundamental laws of peaceful self-governing, and on where we currently stand on the road to inevitable, sustained world peace, as told by somebody other than a non-gay dumbass moron. Okay, so that's my... Okay, so you go down to our links, and the most recent, I believe, is Young versus Garcetti, but I'm not... That discusses some stuff that might definitely get me suspended. And then the other one that might definitely get me suspended is this one. I don't think I could read that without being... We'll see. I don't want to risk it, but I'll read that whole thing later. And then, but the one I'm going to read today is chronologically. I completed this one about the 16th Amendment and submitted it for publication. It's called Understanding the Great Dred Scott Fraud of 1857 Helps Restore the Supreme Court's Full Authority to Strike Down the 16th Amendment as Unconstitutional. So I'm just going to read that today, but I submitted it for publication through Scholastica originally. Once I finished it on 11/22 in 2019, and I just submitted it, I think, to Harvard, of course, Law Review. I guess everybody wants to submit there, and University of Pennsylvania, or something like that. Just 2 of them. I thought for sure it would be accepted immediately, right? It was like 7 years of my life or whatever. I went through law school, and I think I first proposed a lot of this stuff about the fraud in like 2015 and some writings in my law school assignments and things. And then I refined it and looked at it more deeply and put it in a lawsuit, actually, in 2017. I put it in a couple of lawsuits. And then I refined it even more and finally just wrote it out and like in fine detail, everything, and then sent it out for publication. And I believe, anyway, it just got nothing. And then I tried it again in February, got nothing. So then I sent it out to 45 publications that didn't require money, and I did that 45 in February of 2020, February 11th, and that got nothing. And then finally on October 12th in 2021, I paid like $800 and sent it out to every publication that was, every law school publication that was accepting manuscripts. Sorry, I'm if you could hear all the cars zooming by, it's because I'm in a parking lot right now. I'm at the Owens Mouth parking structure of the Westfield Topanga Mall. It's 11 o'clock at night too. It shouldn't be this active here, but you still get a lot of people zooming through. So, and I did get one publication offer from University of District of Columbia Law Review Journal. So, yeah, these were Akron. Look at that, in alphabetical order. A lot of them never even. But anyway, I just said I'm going to submit to 108, and the first people who accept and give me an offer, I'm going to accept the offer. I didn't care. And they were great. But then in December, I think they accepted it pretty quickly, and I accepted their offer. But then in December, they kind of backtracked and said, "Oh, it's going to be too much work. You don't have it in Microsoft Word format." And also they wanted like a table of contents, and they just thought it would be too much work and said reconsider it in the spring of 2023, because they're just law students. You know, I thought I found like somebody who really a champion of it, and it's just the same as I called it epic because it's epic, and maybe that put them off. But it really is. It's quite epic. It's quite brilliant. And I just like, this is what it feels like. I was just thinking about this earlier. You do this whole thing. I worked on it for, 7 years. Not 7. I would say 5 years. But I just worked on it and finally refined it and haven't changed it since, actually. But I might change one thing, and that is, but it's okay, never mind. It's not a big deal. And I feel like I was in a cave, and I went outside, risked my life, slayed the dragon. It was a huge battle. It lasted. I tracked down the dragon. It took me 3 years to track it down. Slayed the dragon, dragged it back to the cave, cooked it up for these people brilliantly, put it on the plate, and then after all that, I'm like, phew, now eat up. And they just went, oh, they looked at it and went, oh, can you chew the food for me and put it down my throat like a mama birdie? And I can't take it. I can't take it. When they return it to me and say, we can't do anything until you put it in Microsoft Word format. And I just like, there's like, I get it. And I'll say, okay, it won't take me. This is what I say. I say, oh yeah, that's no problem. But it is a problem because I have to go to the public library to do this. I have to go to the public library to do this because I don't have Microsoft Word. You have to pay for Microsoft Word. I use Google Docs. It's free. It's way better than Microsoft Word. And I can't stand Microsoft Word anyway. It's the worst. And this is why it's the worst editing program in history. Because women use it. Like all the guys who demand this, a lot of them, well, these women, but a lot of them have like administrative assistants who are women, secretaries, I guess, is the other day. But they do all the Microsoft Word. So that's why it's the biggest garbage program on the planet. If guys actually had to use it as much, I mean, guys do use it, but not as much. They pay women to do all this stuff. So women have to learn it and have to deal with this garbage program, mostly. That's why I believe it's anyway. Also, it's just mostly Bill Gates being very good at abusing a very bad patent law to protect this piece of garbage product. So after the 16th Amendment comes down, things will be chosen by who makes the best product, and who politicians will be chosen by who best represents their constituents, and businesses will be chosen and do well by who makes the best product most efficiently and who treats the workers best, and all this stuff. Now it's not none of that stuff. Now it's just all garbage and corruption. But so I'm just going to read it straight through. Here it goes. It's epic, and it talks about Dred. Okay, let's just go for it. Where is it? So I just got it. I showed you where I got it from. It's online. If YouTube goes down, then I'm not sure. Oh, if YouTube goes down, let me just tell you, it's a lot of my stuff is at my website that started everything. It's called Rights for Families. rightsforfamilies.wordpress.com, and it's there actually. All the other files are there too, but it goes on. I have a lot of stuff. Think Tank, there was grant proposals. The only thing I don't have there is my recent lawsuits, but you could find them all. Just look up my name, Young versus whatever. I have like a whole bunch of them filed in the federal court, and Rose versus Davis was my first one. Anyway, very good. They're brilliant. They're all brilliant. So let's, without much further ado, rightsforfamilies.wordpress.com. If YouTube takes down everything, and we're going to read Understanding the Great Dred Scott. Okay. The Dred Scott versus Sandford case of 1857, which is universally considered one of the worst Supreme Court decisions in history, and is often cited as an instigator of the Civil War, is impossible to brief in a reasonable manner unless an approximately 11,000-word tirade disparaging the entire African race is removed from the majority opinion. The tirade, which begins with the sentence, "This is certainly a very serious question," and ends with the paragraph beginning with, "Now, if the removal of which he speaks," expounds upon an outrageous argument presented by defendant John Sandford in a plea in abatement against a claim of jurisdiction, stating that anybody of African descent is not human under the U.S. Constitution and can never be a U.S. citizen, a stance which was not supported by a majority of the population at the time, nor by any of the 8 concurring dissenting opinions. This tirade stands in direct contrast to the writing style and reasonable arguments presented in the rest of the majority opinion penned by Chief Justice Roger B. Taney, and is not directly referenced nor even acknowledged to exist in 7 of 8 concurring dissenting opinions. It is proposed this tirade was inserted by corrupt pro-Congress anti-Supreme Court factions in government, industry, and or media, early in the majority opinion for maximum impact and distraction from the rest of the opinion, just prior to widespread release to undermine the decision of the Supreme Court on the only true controversial issue of the case, that Article 4, Section 3, Clause 2 of the U.S. Constitution does not grant Congress authority to acquire and hold U.S. territories as colonies, deciding the rights and privileges of people living in these territories at will, independent of the rights and privileges granted in the Constitution. In other words, that the Missouri Compromise was unconstitutional because Congress deemed that some U.S. citizens living in some territories had the right to own slaves, while other U.S. citizens living in other territories did not have this right. It is proposed the fraudulent opinion was released as Dred Scott versus Sandford with a D, while the real opinion, which is arguably the second best penned majority opinion in the history of the Supreme Court after Marbury versus Madison, was called Dred Scott v. Sandford without the D, the actual name of the defendant. This charade represents one of the greatest frauds in U.S. history committed against the Supreme Court of the United States, for which neither the Supreme Court nor the rest of the country has yet to recover. The fraud not only undermined the power of judicial review that the Supreme Court possesses over acts of Congress. Dred Scott represented only the second time in history the Supreme Court exerted its power of judicial review to strike down an act of Congress as unconstitutional. the first time being the landmark case of Marbury versus Madison. But the charade also undermined an as yet officially recognized power of judicial review the Supreme Court must also inherently possess over the amendment process. This weakening of Supreme Court powers eventually led an emboldened Congress to make significant, detrimental changes to the Constitution when the 16th Amendment was ratified in 1913, whereby Congress granted itself unchecked power to collect unapportioned direct taxes at will against specific provisions in 3 different places in the Constitution, restricting this power from Congress. The ability of Congress to collect unapportioned direct taxes at will threw a giant wrench in the system of checks and balances the framers originally set up, and is the main source of dysfunction and corruption in the federal government, i.e. the D.C. swamp we have today. Attempts by President Donald Trump to make America great again by weaning the federal government off of unapportioned direct tax revenues, i.e. income taxes, and instead relying on pre-16th Amendment revenues from indirect taxes such as tariffs and consumption taxes, as originally intended and as originally practiced without a hitch for over 100 years, has led Congress to fight back in unprecedented ways to retain its unconstitutionally self-granted powers of unapportioned direct taxation. Once President Trump completes the process of weaning the country off of the unconstitutional collection of income taxes by the federal government, the Supreme Court, rightfully exerting its full authority of judicial review over the amendment process and striking down the 16th Amendment as unconstitutional, becomes the second important step in reversing over 100 years of government dysfunction and corruption instigated by the great Dred Scott fraud of 1857. So the problem is nobody has ever read the case. Nobody reads anything apparently, because doing these case briefs was my absolute favorite part of law school. I just loved, this was my favorite, and the ones they chose were really like I know Harvard, that's all they do is these kind of law reviews are, and all they do is copy each other. I mean, they just copy off of Wikipedia, whatever. I completely did every one of these on my own, independently, from scratch, and I read through all the lines, and I was just torpedoing all these. I just figured all sorts of, the Supreme Court was so horrible on a lot of stuff. They were so wrong on so many facts on a lot of these cases and things, and the facts were weird. And anyway, so yeah, this is my favorite thing to do. And when I reviewed this, I actually read the case and came up with my, I wanted to get to the core of what the problem was. Why is this the worst case in history? What was the reasoning? Where did the reasoning fail? And the reasoning didn't fail at all. It was a very well-written case. Once you take out this tirade that didn't make sense, it was like, once you took that out, the reasoning makes sense. It doesn't make sense, and there's a lot of other reasons why it was taken out. But here we go. Okay. The problematic sections of Dred Scott versus Sandford. And I know I need a table of contents and put it in Word format, and they said I didn't have enough references or something. It's like I don't know what you want me to refer to. I'm referring to the Constitution and the actual, and everything, and the actual, I'm trying to brief a case. So what references do you want? I'm briefing a case, and I have the case brief at the end, and this file at the end is the actual case brief. But you can't brief, it's impossible to brief this case unless you take out this tirade. Try it, everybody. Try it independently. And try actually reading the damn case that you're briefing. Harvard. God. Anyway. The problematic sections of Dred Scott versus Sandford with a D. While attempting to brief the controversial case of Dred Scott v. Sandford of 1857, And also just Google it. I didn't even put the citation in here. There's no whatever. Just Google Dred Scott versus Sanford and you could link directly to the case. It's online, everybody. So I don't know what citation, whatever. Do you want me to put the citation in there? Why? Gets in the way. Makes it look more professional. Is it form over function again? Yeah, of course it is. Anyway, whatever. I just, now they want me to chew the food and feed it to them like a mama bird, I guess. I can't take it. Okay, anyway. While attempting to brief the controversy, if you just read the abstract, how long did that take? Like 3 minutes? Like, are you serious? Even a high school, I don't know what, I know why it is. People say it's because I mentioned Donald Trump in there. And I did that on purpose because that's what he's doing. And they would say, well, if you took Donald Trump out of the abstract, then, they would be accepted. And it's like, what the, I knew that. I know that. But I'm not trying to get it accepted. I'm trying to tell the truth, and find the one school out of 108 that will accept it. And I did, and then and now they wanted it. They wanted me to chew it even more or whatever. I just wrote them about 20 minutes ago and said, is there an update on this? Are you guys willing to publish this in the spring of 2023? Otherwise, I'm going to, do all the changes they want and then do another blast, I guess, to see if it gets published. And we'll see. It's just going over this. Okay. The problematic sections of Dred Scott versus Sanford. While attempting to brief the controversial case of Dred Scott v. Sanford, it becomes apparent from several red flags that it must be an altered document. The red flags are: A. Breaks in the logical flow of the arguments being presented. B. Grammatically incorrect or illogical segue paragraphs. C. Baseless conclusionary statements that are uncommon for a Supreme Court justice. And D. An unseemly infatuation with discussing race and disparaging the African race in particular, but only in concentrated areas of the document. Without even getting to the concurring dissenting opinions, it is clear from these red flags alone that an approximately 11,000-word tirade disparaging the African race had been fraudulently inserted near the beginning of Chief Justice Roger Taney's majority opinion, and that the only way for the majority opinion to make sense and be briefed in a logical manner is for the tirade to be removed. The fact that 7 out of 8 concurring dissenting opinions in Dred Scott versus Sanford do not reference this tirade, despite its highly inflammatory conclusion, is another red flag in and of itself that this tirade was not a part of the original majority opinion. If anybody actually reads the freaking effing case, read. God, I can't believe how many people just don't read anything. They just go, anyway, unless this has been known at the highest levels of, no, I doubt it. I doubt this. Kushner reads. Jared Kushner read this, I'm sure, and he possibly is the one who, I don't know anyway, just publish it. And you can bury it after it's published. I just want it published other than on my website. Because that is now no longer, who knows, I need it published somewhere because it just seems like publishing it on Twitter, publishing it on a website, publishing it at YouTube, anything like that, it could just all go out the window, I guess. Maybe. Whatever. Once this 11,000-word tirade is removed, other problematic areas become more noticeable, including 2 illogical conclusionary paragraphs that directly reference the tirade, one toward the end of Taney's majority opinion, and one toward the end of the dissenting opinion of Justice Curtis. The paragraph from Curtis's opinion is significant in that it contains the only reference to the tirade in all 8 concurring dissenting opinions, so that once this paragraph is removed, not a single concurring dissenting justice acknowledges the existence of the tirade. Finally, as discussed below, and that was removed too. What I'm doing is I'm trying to get the original opinion and the original dissenting opinion so that I can brief the case. So that's what I did. I got the original opinion according to extremely airtight logic. It's like so freaking airtight. It's you can't even breathe. It's so airtight. Okay, and I just want somebody to review this and tell me otherwise. Just one person freaking read this freaking paper. I'll pay you $1,000. Well, I don't have $1,000. I'll pay you whatever. I'll pay you over a long term because I'm paying for my Invisaligns right now, but I'll pay you whatever. Okay, just an expert. Read the freaking thing and tell me what you think. It's the same with everything I've written. I mean, I can't get a single expert anywhere to tell me garbage because either I don't know what. Like, just maybe it's so airtight nobody wants to touch it. It's just crazy. Finally, as discussed below, the concurring opinion of Justice Daniel is illogical and contradictory until 4.5 paragraphs, appearing to try to change the original conclusions of Daniel while simultaneously disparaging the African race in ways similar to the tirade in the altered majority opinion, are removed. So that's what I did. I removed the 11,000 word tirade, which is all one chunk, and then I removed a single paragraph in the majority opinion. I removed the 11,000 word tirade all at once, and then a little paragraph, and then I removed one paragraph in Justice Curtis's dissenting opinion, and then I removed 4.5 paragraphs from Daniel. That obviously this surgery obviously needed to be done because these were obviously added, and I don't have the tools, I don't have anything to go check the original, anything. I don't have any of this stuff. Okay, I'm just telling you where to look and go find it if they haven't already buried it and covered it and did whatever. But use whatever forensic history. I don't know how you could do this, but it's so freaking blaringly freaking obvious. It's actually so obvious that everybody's going to claim they knew this before and we just didn't say anything about it or something. I don't know what. It's one of these things that I don't want credit for it. I just want it published somewhere so that we could find it. What was it? In The Big Bang Theory? Remember, there was one thing where they said, on the first episode, it's like, the world's about ready to explode, or we're about ready to, what's the most important thing you do? And then he was just doing a roommate test. And then he said, conserve the information. Protect the information. And he says, correct. Remember that? And it's like, I'm just trying to, but then again, I also think that everything I learn, everybody knows automatically, subconsciously. So maybe it's just, that's why I just give up sometimes. I don't even. Okay, so I'm reading it now, and then I'll be done. I'll try again, maybe to get it published, but I don't think the publish isn't. I don't think that is preserving it. I think it's just preserved subconsciously, maybe. So that's probably why I don't try harder. Finally, as discussed below, the concurring opinion of Justice Daniel is illogic. Okay, until they're removed. In addition, what must have originally been the word manumission appears to have been changed to emancipation in 4 different places in Daniel's opinion in order to give the appearance that Daniel's opinion agreed with the conclusions of the tirade when this was not Daniel's intent at all. And that the real name of the defendant was John Sanford without the D. I have one reference there. I think that's the only reference I have other than the Constitution and the actual opinion. The final changes made to Dred Scott versus Sanford in an attempt to reproduce the original unaltered document as best as possible is that all the Sanfords in Dred Scott versus Sanford, the mention of the name, were changed to Sanford. No attempt was made to sort out the first 8 pages of summary of the case, as you'll see, and I reference where the case is there, as it is not clear if that section was written only in part or entirely by the fraudsters, which would make it an original unaltered document. So I don't want to goof around with that. It's the original fraudsters who did that. The proposed unaltered original case with all the aforementioned changes is therefore called Dred Scott v. Sanford, and it is available, the opinions only, in the attached file called Dred Scott v. Sanford, opinionsonly.pdf. This is when I'm submitting this to Scholastica. The aforementioned problematic sections of Dred Scott versus Sanford that were removed or changed in order to create Dred Scott versus Sanford are available in the attached file called Dred Scott v. Sanford fraud sections.pdf. In other words, if you put together the fraud section file with the opinion file, you'll get Dred Scott versus Sanford. Finally, the case brief for Dred Scott v. Sanford is available in an attached file called Dred Scott v. Sanford case brief. So all these different files are submitted when I submit it for publication. How the problematic 11,000-word tirade in the majority opinion of Chief Justice Taney was flagged down and removed. A brief history of the case tells us that Dred Scott was a slave who lived in the state of Missouri in the early 1800s, where slavery was legal at the time. During the 1830s, Scott traveled with his owner from Missouri to two different areas where slavery was illegal: a U.S. territory that was deemed slave-free by an act of Congress, commonly known as the Missouri Compromise, and the state of Illinois, which was also deemed slave-free. When Scott returned to Missouri with his owner at the time, John Sanford, Scott asserted in Missouri State Court that he automatically became both manumitted and emancipated because he had traveled with his owner to slave-free areas of the country. And as a free man, Scott could sue his owner, Sanford, for battery. The Supreme Court, so go look up, later on it will become important, the difference between emancipation and manumission. If you're manumitted, that means your owner has set you free. If you're emancipated, that means the government has set you free. Meaning, if the owner can set you free and you're a free man. I explain this later, but if you're this is mostly written for lawyers, by the way, but I'm not going to bend down. It's going to be 50 times longer. It's already long enough as it is, but if I have to, go through and explain every little thing, look the freaking thing up. I'm not going to chew that food and put it in your mouth. Okay? If you don't understand something, go look it up. I swear to God. He automatically became both manumitted because he had traveled with his owner. Okay. The Supreme Court of Missouri ultimately decided, based on Missouri state law, that Scott's actions made him neither manumitted nor emancipated. Scott then brought the same case to federal court under diversity jurisdiction. I'm not going to explain that either. Come on, you guys. I told you, it's written for law students. First year, probably law students should be able to understand this. Okay? To federal court and people who are put on law school journals as editors at all these law schools, they should absolutely freaking understand this and recognize its importance. Otherwise, I don't get it. They're not reading it then. Or I don't get it. Or they saw Trump and didn't read it or it's what's going on in the medical field, which is there's the opposite of evidence-based medicine. What is that called? It's called eminence-based medicine, meaning they just look up who is submitting it, and they saw that I was not affiliated with anything and whatever, I'm just this target worker and that's it. Once you do that, nope, they're not even going to open their little closed brains, even a little crack, to see what's going on. So okay, enough. I didn't mean this to be, I just meant to read this without insulting the world. Scott then brought the same case to federal court under diversity jurisdiction, claiming Sanford, who had moved away from Missouri by that time, was a citizen of New York, while Scott was a citizen of Missouri. Diversity jurisdiction means you're from two different states. Sanford claimed the U.S. Circuit Court, and it was called the Circuit Court at the time, and it was the equivalent of our district courts now. Sanford claimed the U.S. Circuit Court did not have jurisdiction because Scott, quote, was not a citizen of the state of Missouri, as alleged in his declaration, being a Negro of African descent, whose ancestors were of pure African blood, and who were brought into this country and sold as slaves. Oh, I guess I need the citation there, but it's in the freaking lawsuit. Like, it's right there. I'll show you where the quote is. I don't know what. Okay. This was Sanford's. I just hate, like, what is, do you not believe that it's there? Or just freaking do a word search and you'll find it wherever it is. Like, why do you need a citation there? It just ruins the flow. But I guess I could put one in there for where it is exactly in the freaking page 2 dash whatever. Good Lord. Jeez. Just, okay. Anyway. And that's the editor's job anyway. This was Sanford's only argument. To this, Scott, this was his only argument. By the way, read what he's saying. Read what he's saying. It's like, Scott was not a citizen because he's black. That was the argument. I mean, what the hell? I mean, okay, I'm going to explain later what this is. It's very gay Nazi, by the way, to take extreme arguments like this and like just to piss people off. This whole thing is very gay Nazi. The fraud was committed by gay Nazis. I don't mention that here, but it was. You could, if you don't know me by now, you will never know me. Okay. This was Sanford's only argument. It truly was in the court. To this, Scott basically answered, "Yeah, so," like me, like read what he's saying, people, and you'll see what Scott is basically saying. Yeah, so what? The circuit court, agreeing with Scott, of course, overruled Sanford because Sanford never stated Scott was a slave himself, nor otherwise presented a logical argument for why Scott was not a citizen of Missouri. You can't say he's not a citizen because he's black and his ancestors were slaves or were black, whatever. Once jurisdiction was granted and the circuit court got to the merits of the case, however, the circuit court ruled Scott was still a slave, and the case was decided in favor of Sanford. Not based on the arguments that this moron presented, but just because Scott appealed to the Supreme Court of the United States, but only on the question of his status as a slave, not on the question of whether jurisdiction should have been granted. Probably because the circuit court ruled in Scott's favor on that issue, so they're not going to, they like that. The Supreme Court nevertheless took up all issues, including the issue of jurisdiction and the issue of the constitutionality of the Missouri Compromise, which came up while trying to resolve the issue of jurisdiction. So the controversy here was, you'll see later, can the Supreme Court take up all this stuff? Okay. Taney penned the majority opinion. So this part right here is like when you're doing a case brief. You don't have to, like when you do a case brief, I'm putting in a lot of extra words for other people who aren't people who have briefed cases before, but this is a very, very succinct description of you don't say all the stuff I'm saying. I'm just putting, this is like a case brief right there, the last paragraph, and it is part of the case brief, actually, just like that. Taney penned the majority opinion. The problematic areas in Taney's majority opinion were flagged down and removed as follows. A. So I go through this, and I should probably do bigger. I should probably do a table of contents or whatever. Make this prettier or something, but whatever. Here goes. These are the four main reasons this thing was flagged down and removed. Breaks in the logical flow of arguments. As with any Supreme Court opinion, Taney first sets out to establish that the issues to be resolved by the court are legally before the court. This is typically a 1 or 2 sentence statement at the beginning of an opinion. It's called jurisdiction. But in Dred Scott, there were 2 issues that dissenters argued were not legally before the court. The issue of jurisdiction, specifically the issue of whether Scott was a citizen of Missouri at the time of filing his suit in federal court under claims of diversity jurisdiction, and the issue of the constitutionality of the Missouri Compromise, which came up when the status of Scott as a slave at the time of the filing of the case was being determined. The most logical approach would be to make sure all the issues to be discussed in the case are legally before the court, then delve into the merits of the case. This is particularly true in Dred Scott because the issue of the constitutionality of the Missouri Compromise naturally comes up when attempting to address the issue of jurisdiction. So the two issues are somewhat intertwined. So it can be very confusing, but you need to really talk about jurisdiction in this case. A listing of issues to be resolved, as presented in a brief, for instance, would therefore probably start with these two issues as follows. In other words, this is what the beginnings of the outline to Taney's original opinion probably looked like. And they do. Here are the issues he's wanted us to discuss. 1. Is the issue of jurisdiction legally before the court? 2. Are all other issues resolved in this case, including the issue of the constitutionality of the Missouri Compromise, legally before the court? Okay? That would be the first two things. But this is what happens here. The outline of Taney's opinion in Dred Scott versus Sanford with the D, however, looks like this. This is what it looks like. 1. Is the issue of jurisdiction legally before the court? 2. In addressing the jurisdiction issue, are all people of African descent subhuman and can therefore never be U.S. citizens according to the Constitution? He answers that question. And then he answers the third question, which should be the second question. Are all other issues resolved in this case, including the issue of the constitutionality of the Missouri Compromise, legally before the court? So right away you're going, what the frig is he discussing and addressing and answering this issue right away at the very beginning? And when he didn't even address, it's just out of order. It just doesn't make sense when you're trying to, like, why is he all of a sudden having this 11,000 word tirade answering this question? And then he starts answering, way into the majority opinion after this 11,000 word tirade. He goes, "Oh, now I'm going to discuss whether the issue of is before the court." It's like, no, that's not how it works, people. Okay. Anyway, this red flag highlights an 11,000 word tirade in Dred Scott versus Sanford, disparaging the African race that does not seem to fit into the logical flow of the arguments as they would be presented by a Supreme Court justice. The tirade is 25 pages, twice the length of the next longest argument presented by Taney, which is the constitutionality of the Missouri Compromise, coming in at 12 pages. So the most important argument of the whole thing, really, is the constitutionality of the Missouri Compromise. That's 12 pages long. But there's the whole tirade about the African race, 25 pages. It's just, God. It just does not fit, people. All other issues tackled by Taney in the majority opinion are 3 pages or less. The insertion of this tirade also creates problems by contradicting what Taney says he is actually referring to when resolving the jurisdiction issue. The facts as presented by plaintiff Scott, and specifically not the facts as presented by the defendant Sanford in his plea and abatement, as discussed in the next section. So Taney's contradicting himself in the tirade. And here's how. B. Grammatically incorrect or illogical segue paragraphs. Actually, I think I discussed this later. Okay, anyway, let's just do the segue paragraphs. Grammatically incorrect. The grammar was really bad in the tirade, and I'm really good at grammar. You could ask the Wordle people. New York Times. I think they read this. I am absolutely certain the Wordle people have read this and they recognized, because this is right up their alley. Like, I'm using words. It's like, it's really fun. I need to find my people. They always say find. I know my people are out there. Come, my people. You're like historians, but also like forensic. I think it's called a forensic historian. Is that such a thing? Oh my God, it is so much fun when I did this. They would have so much fun. Maybe they'd be jealous that I got to do this, but believe me, I didn't just it took like 40 years of living to get to this point. Trust me. Okay, go sue a pharmaceutical company when you're 30 years old. And then come back at me later and tell me that I didn't deserve to be in the position to figure all this stuff out. Well, not actually, that came later. This was, tell me you haven't been falsely arrested 5 times and put in jail and had your kids taken from you from the pharmaceuticals. Anyway, I went through hell to get to this point, and it was so much fun. I was living my best life there. I'm living my best life now because it's just so much fun being revealed this stuff. Anyway, grammatically incorrect or illogical segue paragraphs. When slave Scott sued his owner Sanford for freedom in U.S. Circuit Court in Missouri under diversity jurisdiction and claimed Sanford was a citizen of New York while he, Scott, was a citizen of Missouri, the first thing Sanford did was file a plea in abatement. It's just, I didn't know what it was called. I had to go look that up, and even I don't know exactly. But I'm not using the terms here comfortably, like an editor could look at that and say, that's not how you say that, how you phrase it. But I think it's a plea in abatement to Scott's claim. In other words, they're contradicting him. It's like a reply brief or whatever. The first thing Sanford did was file a plea in abatement to Scott's claim that he was a citizen of Missouri as follows. Quote, here I have the reference here on this one. Okay. Said causes of action, and each and every one of them, and any such accrued by the said. So this is old language, but you could figure it out. Read it. Figure it out. Said causes of action, and each and every one of them, if any such accrued to the said Dred Scott, accrued out of jurisdiction of this court, and exclusively within the jurisdiction of the courts of the state of Missouri. For that, to wit, said plaintiff, Dred Scott, is not a citizen of the state of Missouri as alleged in his declaration because he is a Negro of African descent. His ancestors were of pure African blood and were brought into this country and sold as Negro slaves. And this the said Sanford is ready to verify, wherefore he prays judgment whether the court can or will take further cognizance of the action aforesaid. He's just saying he's not a citizen because he's a Negro of African descent. That's all. If you are black, you can't be a citizen. And there were plenty of citizens then who were black. I don't know what they're trying to say. I mean, it's just crazy. It's like they're taking... I'll explain it later what they're doing. It's very Nazi. It's very gay Nazi. They're doing this shit now. Anyway, it's just patterns just repeating themselves, by the way. Including it's just fake news that stem from this. They controlled the media after this, apparently. Okay, whatever. The circuit court took one look at this argument that Scott could never be a citizen of Missouri simply because he was a Negro of African descent, agreed with Scott to throw it out on its face, granted jurisdiction, and told Sanford to proceed with arguing the case on its merits. It was only after the circuit court granted jurisdiction that it took a look at the arguments presented by Scott that he was a free man because he had traveled to slave-free areas of the country with his owner, which is equally stupid in the other direction. Do you see what this is? It's like they came in... It's the lawyers doing this, by the way. The lawyers are gay Nazi assholes, as they are now, on both sides of the case. They're not fighting for Scott. They're not fighting for Sanford. They're fighting for a political outcome. So they are working together for a political outcome. And what they're doing is they're making extremely stupid arguments on both sides. And I don't know what, like, it's just to be very polarizing, and it's a divide and conquer, and they've been doing it since then. It's like Scott's argument is equally stupid to say, well, I just traveled through the area with him, therefore I'm a free man, without filing anything, without asking for emancipation, without asking for manumission, without anything. It's like nothing official. He just says, well, just by traveling there. And it's just like, you can't, I mean, it's not, I don't know. It's stupid at the time, and everybody's going to say, oh, no, whatever. I'm tired of okay, let's go. The circuit court took on, and they said, forget it. Okay. This decision on jurisdiction became a main point of contention in Dred Scott because, as Taney argues in the original opinion, just the fact that Sanford questioned citizenship in his plea by claiming Scott was not a citizen of Missouri should have been enough to cause the circuit court to take a thorough look at the issue of jurisdiction, using all the facts available to both parties, not just the opinions presented by Sanford in his plea. Had the circuit court done this, they would have seen that it was the stupidest frickin' argument on the planet on purpose. Okay, had the circuit court done this, they would have determined that Scott was a slave at the time of filing his case and that there was no jurisdiction. It almost seems like the setup happened way in advance. Like they were setting up the court. It was a setup. Like way in advance, they made the arguments on both sides so stupid that they really made sure that it was... anyway, okay. I'm sorry. Let's just do this. This decision on jurisdiction became a main point of contention. Are we working on an hour now? Okay, I might not read the whole thing. I might not even get through. Who cares? I usually like to be out of here before midnight, though. And I work at 2:00. I'm just going to keep reading until I have to get out of here and go to work. I'm not in the Target parking lot either, so I have to get out. I have only another hour, maybe an hour and a half. Okay. This decision on jurisdiction became a main point of contention in Dred Scott because, as Taney argues in the original opinion, just the fact that Sanford questioned citizenship in his plea by claiming Scott was not a citizen of Missouri should have been enough to cause the circuit court to take a thorough look at the issue of jurisdiction, using all the facts available by both parties, not just the opinions, the stupid opinions presented by Sanford in his plea. Had the circuit court done this, they would have determined that Scott was a slave at the time of filing his case and that there was no jurisdiction. They had to defer it to the state court in that case. And I'll explain that later. I explain it later. I do explain this stuff to people who aren't like law students, but you'll know later that okay. In contrast, the main argument of the two dissenting opinions on this issue by Justices McLean and Curtis is that the circuit court was correct in looking at only the argument presented by Sanford in his plea and abatement when deciding jurisdiction, so that not only was the circuit court correct, according to the dissenters, on this decision to throw out the plea and grant jurisdiction, but the Supreme Court had no authority to question the lower court decision by bringing in the facts presented by Scott outside of Sanford's plea. Taney readily dismisses this argument in his majority opinion when he writes, and of course he readily does it, and we're still practicing this to this day. Okay, a first-year student should do this. The arguments are so stupid here. Taney he does a good job on the Missouri Compromise, but this stuff is like, what the frick arguments are these? They're so stupid. He gets rid of them in like one paragraph each. He writes, quote, "The case before us still more strongly imposes upon this court the duty of examining whether the court below has not committed an error in taking jurisdiction and giving a judgment for costs in favor of the defendant. For in Capron v. Van Norden, the judgment was reversed because it did not appear that the meaning he put the emphasis in there, not me. Not appear was in italics, I guess, or just emphasize that the parties were citizens of different states. They might or might not be, but in this case, it does appear that plaintiff was born a slave, and if the facts upon which he, and I put in parentheses, Scott, not Sanford, relies have not made him free, then it appears affirmatively on the record that he, Scott, is not a citizen, and consequently his suit against Sanford was not a suit between citizens of different states, and the court had no authority to pass any judgment between the parties. Parentheses and bold lettering added by me. Okay, the facts upon which he, Scott, relies have not made him free. And it's true, you can't just say he didn't file anything. He just says I traveled through a state that was free. with my owner, and therefore I'm free. He just made up the law himself on that case, right? The lawyers knew what they were doing. Stanford, I'm sure, was not saying this. He was like, he had other arguments. There were way better arguments to put the question of slavery in this whole thing, but it was so bad. They twisted it around to make this whole big controversy because they're assholes, even back then. Freaking lawyers. Not all lawyers, but they were the ones who were being very corrupt here. The gay Nazi asshole ones. Very aggressive and lying and very cheating and very good at manipulating gay men and non-gay dumbass morons. 3 sentences later, Taney confirms that he is using the facts as presented by Scott, the stupid ones, but whatever, and not the facts as presented by Sanford in his plea when Taney is deciding the issue of jurisdiction. Taney writes, "We proceed, therefore, to inquire whether the facts relied on by the plaintiff," in bold letters, entitled him to his freedom. Okay? Not what Sanford was saying, that he's black, therefore he's not a citizen. That's not what Taney is saying when he's deciding jurisdiction. He says he's a slave and he is not a citizen because he's claiming to be a citizen because he didn't file anything. He didn't make it official anywhere. He just claimed it. Pretty much, okay? So he's still a slave. Okay, you want to be manumitted, you want to be emancipated, all these things, you have to do certain things under the law. You can't just run around saying I'm free when your own owner didn't say it. And the government didn't say it. It's just not the way it works, people. I mean, you're saying, oh well, now you're favoring the slave owners. No, I'm favoring freaking law and order. And I know when you say that, everybody bristles. So we should say something else. Don't say law and order, because I bristle at that too, because that's what Republicans use. That's what when they're big fascists. I wish Trump wouldn't say that, because it's got all sorts of connotations about police brutality is okay and all this crap. Do not say law and order, even though it's the name of that series. You can't. It's just like when they said, "Oh, we stole all the land from the Native Americans." It's just like they didn't. You can't have a country without ownership of property by the people there. I mean, you have to have ownership, especially, when there's 5 people in the entire country, fine, you do whatever they want. But when you have populations and it's growing population, you can't just wander around and say, well, okay, we'll just pretend to own it or not own it or whatever. The Indian, and in order to have ownership, you have to have deeds and writing and laws. They didn't write. They didn't have deeds. They didn't have records. They didn't believe in ownership. So it's like, how the fuck did we take stuff from people who don't believe in ownership? Did you want us to all just become Native Americans and wander around from place to place? I don't know what people expect when they say we stole it from them. Like what? How can you steal something from people? You can't make a deal with them. You can't do anything. So yeah, of course you're gonna take it take whatever. We tried to buy it from them, I guess, and they said, "Oh, we didn't pay him enough," or whatever. It's so stupid, fucking stupid arguments. Get your heads out of your asses, everybody. God, I'm just like, I can't stand this stuff. I can't stand this. I mean, I really. Going to law school, everybody just go to law school and don't and do it and learn independently, or don't go to law school until you've been to jail 5 times and until you've sued a freaking swamp, or I don't know what. I don't know. I'm being very impatient. I'm sorry. Anyway, I'm not siding with. I don't know why I'm being defensive. I think I'm trying to reach more than Trump and Jared Kushner right now. And I think I'm trying to do that, and it's making me very frustrated, because maybe I don't want to do that still. I do want to do it, but I guess I'm not doing a good job. I have to be more patient. I forget how long it took me to learn this stuff. So I expect everybody. I think it's because once I learn something, I expect everybody to know it, from the child who's a day old, subconsciously, I think. So that's why it's, and also what I've been saying this stuff in particular for 7 years now, 8 years, all this stuff, and it's just like, and I can't even get it like published. Anyway, 3 sentences later, Taney confirms that it is using the facts. Okay. Unfortunately, these very clear statements by Taney concerning exactly what facts he is using in his arguments only show up later in his opinion, when he is defending the idea that all issues were properly before the court, not just the issues of jurisdiction. This offered an opening for the fraudsters when, at the end of his 3-page argument for why the Supreme Court has authority to review the jurisdiction issue, the first issue tackled in the majority opinion, this is what Taney writes. So it's a little bit confusing because you could see where they came in, and they used, they came in at a place where it would be most confusing. Because you put in the tirade, and then he says this. Okay, quote. This is where he writes this. We think they are before us. The plea and abatement and the judgment of the court upon it are part of the judicial proceedings in the circuit court, and are there recorded as such. And a writ of error always brings up to the Superior Court the whole record of the proceedings in the court below. And in the case of the United States versus Smith, 11, whatever the reference, this court said that the case being brought up by writ of error, the whole record, the whole record was under the consideration of the court. And this being the case in the present instance, the plea and abatement is necessarily under consideration, and it becomes therefore our duty to decide whether the facts stated in the plea are or are not sufficient to show that the plaintiff is not entitled to sue as a citizen in a court of the United States. The problem here is the ambiguity in the statement. Quote, it becomes therefore our duty to decide whether the facts stated in the plea are or are not sufficient to show that plaintiff is not entitled to sue as a citizen in a court of the United States. By facts stated in the plea, does Taney mean the fact that Scott is a slave, impliedly, and the fact that Scott is not a citizen of Missouri? Or does Taney mean the fact that Scott is a Negro of African descent, and the fact that all Negroes of African descent can never be citizens of any state? It is not as clear here as it is in Taney's later arguments that Taney is referring only to the claims made or implied by Sanford that Scott is a slave and that Scott is not a citizen of Missouri. It seems the frauders recognize an opening to exploit this ambiguity, because here is the point where Taney supposedly launches into an 11,000-word tirade establishing the quote-unquote fact that all Negroes of African descent can never be citizens of any state, the same claim Sanford made in his plea and abatement. The tirade begins as follows. Now, this is not him writing this, okay? It goes like this, quote, this is certainly a very serious question, and one that now, for the first time, has been brought for decision before this court. But it is brought here by those who have a right to bring it, and it is our duty to meet it and decide it. This is not him writing this shit, by the way. The question is simply this. Can a Negro whose ancestors were imported into this country and sold as slaves become a member of the political community formed and brought into existence by the Constitution of the United States, and as such become entitled to all the rights and privileges and immunities guaranteed, by the way, the guaranteed is IED, and guaranteed is, Taney doesn't write guaranteed like that, I'm pretty sure. I just couldn't find it anywhere here, but if you look for it elsewhere, he doesn't write guaranteed like that. With a GUARANTIED instead of TEED, by the instrument to the citizen, one of which rights is the privilege of suing in a court of the United States in the cases specified in the Constitution. Okay, so can a Negro existence by... Okay, question mark. As discussed below... So, this is not a question. Taney never presented this question. That's not the question he's talking about. He's talking about whether or not jurisdiction should be... Whether or not... Scott is a slave as according to his own arguments, as according to Scott, not according to Sanford and this arguments that if you're black you can't become a citizen because you're subhuman. He never said that, and that wasn't the argument. These guys are, this is the beginning of the tirade. As discussed below, the off-the-wall rants against the African race and all the conclusionary statements without bases, as if a law student wrote them over the next 25 pages, is a big red flag that something is not right. But it is the attempted segue paragraphs at the end of this tirade that really give away the fact that this tirade was not a part of the original opinion. The 6 paragraphs at the end of the tirade are as follows. This is how... That was the beginning of the tirade, and I showed where they saw an opening and put this in there, and it really stands out. And logically, it doesn't fit there, and in all other ways. And I also showed that the grammar is distinctly different from Taney's grammar, like with guaranteed and other stuff. But I'll show that later. But I needed to find where it ended, and to do a clean cut it completely out. Okay, and here are the 6 paragraphs that at the end of the tirade. Quote. And upon a full and careful consideration of... This is 25 pages later. 25 freaking pages later. Really. The whole thing is 45. I think the whole thing... Anyway, it's like... Once you take this out, it goes from 45 pages to like something normal. Like 20 pages or something. Whatever. And upon a full and careful consideration of the subject, the court is of opinion that... This is not Taney writing. That... Upon the facts stated in the plea of abatement, Dred Scott was not a citizen of Missouri within the meaning of the Constitution of the United States, and not entitled as such to sue in its courts, and consequently that the circuit court had no jurisdiction of this case, and that the judgment on the plea of abatement is erroneous. Yeah, the judgment is erroneous, but not for those reasons. Okay, and he went on to write. The tirade went on to write. The gay Nazi assholes writing this went on to write this. We are aware that doubts are entertained by some of the members of the court whether the plea in abatement is legally before the court upon this writ of error. But if that plea is regarded as waived or out of the case upon any other ground, yet the question as to the jurisdiction of the circuit court is presented on the face of the bill of exception itself, taken by the plaintiff at the trial, for he admits that he and his wife were born slaves, but endeavors to make out his title to freedom by citizenship by showing that they were taken by their owners to certain places hereafter mentioned, where slavery could not by law exist, and that they thereby became free, and upon their return to Missouri became citizens of the state. That's a run-on sentence. Okay, I'm just telling you now. I'm giving away the big... it's like a... Now, and he goes on to write, now, if the removal of which he speaks did not give them their freedom, then by his own admission he is still a slave, and whatever opinions may be entertained in favor of the citizenship of a free person of the African race, no one supposes that a slave is a citizen of the state or of the United States. If, therefore, the acts done by his owner did not make them free persons, he is still a slave and certainly incapable of suing in the character of a citizen. The principle of law is too well settled to be disputed that a court can give no judgment for either party where it has no jurisdiction, and if upon the showing of Scott himself it appeared that he was still a slave, the case ought to have been dismissed, and the judgment against him and in favor of the defendant for cost is, like that on the plea of abatement, erroneous, and the suit ought to have been dismissed by the circuit court for want of jurisdiction in that court. Taney wrote that part. But before we proceed to examine this part of the case, it may be proper to notice an objection taken to the judicial authority of this court to decide it. And it has been said that as this court has decided against the jurisdiction of the circuit court on the plea of abatement, it has no right to examine any question presented by the exception, and that anything it may say upon that part of the case will be extrajudicial or mere obiter dicta. Okay, so this is a manifest mistake. There could be no doubt as to the jurisdiction of this court to revise the judgment of a circuit court and to reverse it for any error apparent on the record, whether it be an error of giving judgment in a case over which it had no jurisdiction or any other material error as to whether there is a plea in abatement or not. Okay, what they're saying is, the argument was, well, once you say there's no jurisdiction, you can't go on and review other stuff in the Supreme Court. And they're saying, yeah, what if they gave jurisdiction and then they made these arguments that were erroneous about, and they said all sorts of garbage that's not right? We have a right to go in and change that. And you'll see later. I mean, of course they do, and they do to this day. They can do whatever the hell they want, actually. Okay, so this is me writing. The second paragraph, beginning with, "We are aware that doubts are entertained by some of the members of the court whether the plea in abatement is legally before the court upon this writ of error," is most problematic, and that is presenting an issue that Taney has already asked and answered 25 pages earlier. Okay, whether the plea in abatement is legally before the court. He answered. I read it earlier. So why are they bringing it up now at the end of their tirade? I mean, they just made a mistake. In addition, the rest of this paragraph, beginning with, "But if that plea is regarded as waived," is a run-on sentence that makes no sense and represents the only run-on sentence in the entire case, including the 180 pages of concurring dissenting opinions. This was a long-ass case. Read it, motherfuckers. Anyway, I mean, if it's the worst case ever written by the Supreme Court in history, read it and figure out why and where they went wrong. I mean, I can't believe. Anyway, just okay. The next paragraph, beginning with, that's how Holocausts happen, by the way. It's just the next paragraph, beginning with, "Now, if the removal of which he speaks appears to refer to the illogical paragraph above, so it seems to belong to the tirade. Then again, the paragraph seems to set up the argument that Scott was not a citizen of Missouri, according to facts presented by Scott himself. Okay, regardless of the facts presented by Sanford in his plea. So it may have been written by Taney, because that's his argument, in preparing to address the issue of jurisdiction from the facts presented by Scott. However, that this paragraph was a part of the tirade and was in fact the last paragraph of the tirade was confirmed later by the mention of the term African race in this paragraph, which, as described below, was a term never used by Taney, except 21 times in the removed tirade, including this paragraph, nor by any of the other justices in their concurring dissenting opinions, with only two exceptions. One sentence in the dissenting opinion of Justice Curtis as follows: "I shall not enter into an examination of the existing opinions of that period respecting the African race, nor into any discussion concerning the meaning of those who asserted in the Declaration of Independence that all men are created equal." So Curtis is on the side of, he's saying, I'm not even going to mention African race except this one time to say I'm not going to even mention that because that has nothing to do with shit. And he's right. Okay, so he mentions it there. That's the only other time. Except there's another one. It's in an illegal contradictory paragraph in the concurring opinion of Justice Daniel that was eventually removed as one of the 4.5 fraudulent paragraphs in his opinion. As was typical, the term African race was used disparagingly in that fraudulently inserted rant as follows. So once it became obvious that nobody wanted to touch that subject of African race, they didn't even want to touch it. And yet here's 25, pages of it. Come on. That's stupid. Okay. So once I figured that out, and they were just like now, they're not going to touch that. It's very controversial to talk about that. It didn't have anything to do with anything, like whatever. I mean, as far as they were just focusing on, is he a slave or not according to the laws now. The African race, they weren't going to start to disparage the entire African race, and there were definitely black people who were citizens at the time. But anyway, okay. So this was from Daniel. I removed this paragraph. It goes like this, quote, that so far as the rights and immunities as pertaining to citizens have been defined and secured by the Constitution and the laws of the United States, the African race is not and never was recognized either by the language or purposes of the former, and it has been expressly excluded by every act of Congress providing for the creation of citizens by naturalization. These laws, as already been remarked, been restricted for free white aliens exclusively. And it's just like, oh my God, Jesus, Mary, and Joseph. Anyway, that paragraph is just freaking so false. That was putting very inflammatory words into Daniel's mouth. Okay? All right. That paragraph was it wasn't 25 pages, but it was 4.5 very wrong paragraphs. And Daniel did not say that. That was the fucking gay Nazi piece of shit assholes trying to do all this shit to our country and to both races and to the world and to everything, because that's what they do. While they are disparage themselves. Because if you look at my rights for families, I say the ones who are only the ones who have their rights stripped away from them early and often want to strip the rights from other people. So that's the gay man. But that's changing, and we'll see. The next paragraph in the majority opinion, beginning with the principle of law is too well settled to be disputed, seems to have been truly written by Taney, because it not only talks about determining jurisdiction from the facts presented by Scott himself and not by Sanford in his plea. Taney writes, quote, and if upon the showing of Scott himself it appeared that he was still a slave. But this statement by Taney logically clears up the ambiguity introduced by Taney in the last sentence he wrote 25 pages earlier. Okay, I mean, it looks like it was 25 pages ago, but they should be connected as follows. The final tirade removed from the majority opinion in Dred Scott versus Sanford therefore begins with, this is a very serious question, and ends 25 pages later with the paragraph beginning with, now the removal of which he speaks. The proposed original version of Dred Scott v. Sanford, without the D, with the tirade removed, not only clearly shows the natural segue between issue 1 is the issue of jurisdiction before the court, and issue 2 are all other issues before the court, but it nicely clears up the aforementioned ambiguity as follows, with the Taney ambiguity and Taney's follow-up clarification shown in bold and explanations in parentheses. Okay, here it goes. We think, therefore, they are before us. The plea and abatement and the judgment of the court upon it are a part of the judicial proceedings in the circuit court and are therefore recorded as such. And a writ of error always brings up to the superior court the whole record of the proceedings in the court below. And in the case of United States v. Smith, 11 Wheat 171, this court said that the case being brought up by writ of error, the whole record was under the consideration of this court. And this being the case in the present instance, the plea and abatement is necessarily under consideration, and it becomes therefore our duty to decide whether the facts stated in the plea, does Taney mean the fact that Scott was a slave and the fact that Scott was not a citizen of Missouri? Or does Taney mean the fact that Scott was a Negro of African, are or are not sufficient to show that the plaintiff is not entitled to sue in the United States? The principle of law is too well settled to be disputed, that the court can give no judgment for either party where it has no jurisdiction, and if, upon the showing of Scott himself, it appeared that he was still a slave, this confirms that Taney above meant the fact that Scott was a slave and the fact that Scott was not a citizen of Missouri. Those were the facts, not anything having to do with African race. Okay. The case ought to have been dismissed, and the judgment against him and in favor of the defendant for cost is, like that on the plea and abatement, erroneous, and the suit ought to have been dismissed by the circuit court for want of jurisdiction in that court. It feels like there's a run-on sentence up here. I just got through saying, God, I should really go through this, huh? We think they are before us. The plea and abatement are part of the jurisdiction and are recorded as such, and the writ of error always brings up to the Superior Court. And in the case of United States versus Smith, this court said that the case Oh, that's not a run-on sentence. Okay. It's like the way they spoke. Okay. The principle. Okay. But before we proceed to examine this part of the case, it may be proper to notice an objection on and on. This is a manifest mistake. There could be no doubt that the jurisdiction revised judgment, blah, blah, blah. Okay, that's the end of it. Okay, then we go on, and the rest of the case is there. So that 11,000-word tirade. So that was showing you the segue paragraphs making no sense, and the whole thing is removed. Once it was decided the tirade was to be removed, a later paragraph in the majority opinion of Taney, where Taney is winding up his 12-page discussion on the constitutionality of the Missouri Compromise, becomes problematic in that it references some of the arguments made in the tirade. The context of that problematic paragraph is as follows. As pointed out in the brief, Taney's takedown of the Missouri Compromise is a master class and how to strike down an act of Congress. It was fantastic. I mean, seriously. It is a very strong argument that stands unscathed even to this day, the implications of which are discussed in another section. There were only two relatively weak dissenting arguments concerning Taney's arguments on the Missouri Compromise, concerning Taney's arguments that the Missouri Compromise was unconstitutional. One was a dissenting argument by Justice McLean, claiming that Chief Justice Marshall had previously deemed the Missouri Compromise as constitutional in his majority opinion in Atlantic Insurance Company versus Cantor. And two, a dissenting argument, mostly by Justice Curtis, that according to many laws of other nations, slaves should not be considered property in the Constitution. So the claim by Taney that Congress was violating property rights in the Missouri Compromise by violating the property rights of slave owners who owned slaves was not relevant, and therefore the Missouri Compromise was not unconstitutional. Those were BS arguments. Taney addressed the first dissent in the main part of his argument, dismissing the dissent and taking the words of Marshall out of context. They really did. After the main thrust of all his arguments on the Missouri Compromise were concluded, Taney addressed the second dissent as follows. You really have to read the Missouri Compromise arguments. They were fantastic. The best 12 pages. So this is what he writes. It seems, however, to be supposed that there is a difference between property in a slave and other property, and that different rules may be applied to it in expounding the Constitution of the United States, and the laws and usages of nations and the writings of eminent jurists upon the relation of master and slave, and their mutual rights and duties, and the powers which governments may exercise over it, have been dwelt upon in the argument. But in considering the question before us, it must be borne in mind that there is no law of nations standing between the people of the United States and their government, and interfering with their relation interfering with their relation to each other. The powers of the government and the rights of the citizen under it are positive and practical regulations plainly written down. The people of the United States have delegated to it certain enumerated powers and forbidden it to exercise others. It has no power over the person or property of a citizen but what the citizens of the United States have granted, and no laws or usages of other nations or reasoning of statesmen or jurists upon the relations of master and slave can enlarge the powers of the government or take from the citizens the rights that they have reserved. And if the Constitution recognizes the right of property of the master and a slave, and it's very key here, if the Constitution recognizes the right of property of a master and a slave and makes no distinction between that description of property and other property owned by a citizen, No tribunal acting under the authority of the United States, whether it be legislative, executive, or judicial, has the right to draw such a distinction or deny it to the benefit of the provisions and guarantees which have been provided for the protection of private property against the encroachments of the government. So what he's saying here, let's just keep going. But he's saying that the Constitution, it trumps anything, all the other, like they can do all the customs they want in other countries. We have written down specific things in our Constitution that, and you can't trump it with some custom in another country, are these arguments. Now, as we have already said in an earlier part of this opinion, this is the paragraph that he did not write. Taney did not write this paragraph. Okay, ready? Now, as we have already said in an earlier part of this opinion, upon a different point, why is he bringing this up now on a different point? The right of property in a slave is distinctly and expressly affirmed in the Constitution. No, he never said that. He says, and it's very important, this part, because this is the most quoted part of the whole thing. This is the most quoted part, and he didn't write it. Okay? He said, if the Constitution recognizes the right of property. He never, the question of whether slavery is granted in the Constitution was never addressed in this opinion. It was never brought up, and that's it. These guys are the ones, the lying assholes, the lying gay Nazi assholes brought it up and answered it in the wrong way. Because it is not in the Constitution. Slavery was not. We do not need the 13th Amendment to take it out of the Constitution. That was the first blow against the Supreme Court, was the 13th Amendment, saying we are interpreting the Constitution. They did the. Now, as we have already said in an earlier part of this opinion, upon a different point, the right of property in a slave is distinctly and expressly affirmed in the Constitution. No, it wasn't. It wasn't a tirade, but Taney didn't write that. The right to traffic in it, like an ordinary article of merchandise and property, was guaranteed. See the guaranteed? T-I-E-D again? To the citizens of the United States in every state that might desire it for 20 years. And the government in express terms is pledged to protect it in all future time if the slave escapes from his owner. This is done in plain words, too plain to be misunderstood. Shit, fuck you. And no word can be found in the Constitution which gives Congress a greater power over slave property, or which entitles property of that kind to no less protection than property of any other description. The only power confirmed is the power coupled in the duty of guarding and protecting an owner and his rights. So this is most quoted of all. This is everything, all the newspapers and everybody since the beginning of time as being Taney's paragraph. It is not his paragraph. It did not state this. Because he's saying, because the right of a slave, because it says, as we already said in an earlier part of the opinion in a different point, the right of property in a slave is distinctly and expressly affirmed in the Constitution. Taney doesn't say that anywhere except in the tirade that was removed. It's not listed anywhere in the majority opinion. Go find it. It's very short. Once you remove the tirade, they said it several times in the tirade. Okay, so this paragraph is removed. So what happens is it just flows naturally. He says, such a distinction or deny it to benefit the provisions and guarantees the private. Upon these considerations, he's done. He didn't need to say that other thing. It is the opinion of the court that the act of Congress was presented holding only okay. Upon these considerations, not with that paragraph, it is the opinion of the court that the act of Congress which prohibited a citizen from holding and owning property of this kind in the territory of the United States north of the line therein mentioned is not warranted by the Constitution and is therefore void, and that neither Dred Scott himself nor any of his family were made free by being carried into this territory, even if they had been carried there by the owner with the intention of becoming a permanent resident. Only the government can make you a citizen, not the owner. He can only make you a free man. He can only manumit you. He can't emancipate you. Okay. The problematic paragraph is the third paragraph that reads as follows. Now, as we have already said in an earlier part of the opinion. Okay. Taney makes no such statements or arguments about the right of property in a slave being expressly affirmed in the Constitution anywhere in his majority opinion. These conclusions come solely from the removed tirade. In fact, in the paragraph just above this paragraph, and what most likely instigated the need to insert this fraudulent paragraph precisely at this point, Taney appears to be purposely ambiguous on the point that a right to own a slave is expressly affirmed in the Constitution, stating, and if the Constitution recognizes the right of property of the master and a slave. This ambiguity leaves open the possibility of a future argument, not addressed by Taney in his opinion in this case, that there is no right of slavery expressly granted in the Constitution. And in fact, the framers were very particular about not even having the words slaves or slavery mentioned anywhere in the Constitution, probably for this reason, that under the Ninth Amendment, the right not to be owned by another human might, and most likely will, someday be recognized as a fundamental human right. So that's where slavery is ended. It's not ended in an amendment to the Constitution. There is no amendment needed. There's already an amendment there called the Ninth Amendment, which says it says all the rights we list in the Bill of Rights is not every right that exists. There are other rights that we are looking over, we're sure, and we're going to take care of that. The Supreme Court will take care of that in the future under the Ninth Amendment. The whole freaking Constitution was written without mentioning slaves and with allowing all sorts of fail-safes to make sure that after 20 years, the only way they can get it ratified is by allowing slavery to keep going for 20 years only. And after 20 years, it was immediately ended as far as importing slaves. Okay, and that put an end to slavery pretty much after that, unless, it was going to go downhill from there, except this freaking bullshit. And what's his name? Andrew Jackson, butthole, the guy who's on our $20 bill and who founded the Democratic Party. Biggest freaking gay Nazi asshole. He taught Hitler everything he knew. This guy was... Anyway. Okay. So that paragraph was removed. So the 11,000 word and that paragraph removed. All right. The crux of Taney's argument and the most important point of the majority opinion is therefore not that the Missouri Compromise is unconstitutional because it deemed slavery illegal in a United States territory in purported violation of an express right of slavery in the Constitution, as many commentators on Dred Scott v. Sanford erroneously conclude, but that the Missouri Compromise is unconstitutional because Congress tried to make slavery illegal in only parts of the country and not others. If Congress had passed the law that made slavery illegal in the entire country, this would be a very different constitutional question to answer, one in which Taney is not so sure would result in deeming such a law unconstitutional. In fact, they're pretty much hinting it would be constitutional to make just a law. Okay? Congress could make that law. You don't even have to. The Supreme Court doesn't even. Yeah, and then when it was challenged, the Supreme Court could refer to the Ninth Amendment and say the humans don't have a right. Whatever. Upon the proper reading, it's not whatever. This is how it should. This is how it was expected to work. And we never use the Ninth Amendment. Nobody knows anything about it, even though that's the most important of all the amendments, pretty much. For a living, what we call a living constitution, which it is a living constitution, according to the Ninth Amendment. You freaking... abortion isn't mentioned in the Constitution, therefore it's illegal. Or, oh my God, Jesus, Mary and Joseph. Yeah, well, murder isn't mentioned in the Constitution either. Uh-oh. There goes the security guy. I might have to go. He might boot me out of here. I'm going to keep going until he boots me out of here. I don't want to do that, though. I don't want to wear out my welcome, but I want to finish this part of it at least. So, all right. It's December 9th. All right. I have a little bit longer before I have to go. Anyway, the crux of Taney's argument is not, but if Congress had passed a law that made slavery illegal in the entire country, this would be a very different constitutional question to answer. One in which Taney is not so sure would result in deeming such a law unconstitutional. Upon the proper reading of Dred Scott versus Sanford, without the D, the non-fraudulent one, an act of Congress would have been the proper course. albeit impractical, if not impossible, after the disastrous effects of Dred Scott versus Sanford. That was the whole point, was to weaken all of our systems, including congressional laws. Of course, to abolish slavery uniformly throughout the entire country, and not an entire constitutional amendment in Amendment 13. Had that act been challenged, the Supreme Court could have addressed the issue of whether there is an express right of slavery in the Constitution, and would most likely have answered that question in the negative, even in the mid-1800s. The 13th Amendment therefore made an improper interpretation of the Constitution based on one fraudulently inserted tirade and one fraudulently inserted paragraph, claiming there was an express right of slavery in the Constitution, implying the only way to usurp that right was a constitutional amendment. As described below, an argument is made that not only supports the idea that the Supreme Court possesses an inherent power of judicial review over the amendment process, but suggests the Supreme Court should use this power, which has no statute of limitations, to strike down the 13th Amendment as unconstitutional, even at this late date. So I want to say here that one of the first things, Elena Kagan was my favorite Supreme Court justice, and I love hearing her. I've watched every speech of hers when she sits and talks, and she's just funny, and I just loved her so much, and she was my favorite. And then, I didn't read it, but she talked about this one case she did. And it was Justice Scalia, Mr. Tobacco Swamp. There were like 3 Catholic justices that came from one place in the tobacco gay Nazi capital of the world in New Jersey. They all came from there. They're all tobacco. And he wasn't gay, but he was killed by the tobacco swamp. You live by the tobacco swamp, you die by the tobacco swamp. And that's exactly what happened to Scalia with his, if you grow your own marijuana and smoke it and don't sell it and don't do anything, it violates the inverse commerce clause. Like, oh my God, Jesus, Mary, and Joseph, people. Like, the worst. That was the worst Supreme Court decision in history. Was Scalia, what was that? Oh, what is that one? Oh my God. The one that kept marijuana illegal because it violated the inverse commerce clause. And I can't even get the speed limit on that. I mean, I made a similar argument over truck speed limits affecting the inverse commerce clause. They said, the zit-faced piece of jerk. They always put zit-faced law intern people in charge of the pro se constitutional challenges. They say, oh, truck speed limits, trucks have nothing to do with commerce or something. I mean, it was the stupidest freaking, oh my God. It was brilliant. And they're going to, anyway, okay, so, but let's get back to Kagan. I think I'm going to end this here. Wait, let me just say Kagan. She argued, oh no, I still smacked. I don't want to do this. You know what? I'm sorry about that, people. I'm going to really try not to do that. It's just these Invisaligns, and they get kind of spitty, and also it's a bad habit where I'm trying to think, and I'll go, sorry about that, you guys. Oh, got to stop that habit. But I have a lot of spit right now, and I don't know how to. There we go. I can do it without going. It's a fake tooth. I'm going to get a tooth in another year or so, and then I'm going to stop that. I'm going to stop it now. See, I could do it without making a noise. There, I just did it. But Elena Kagan wrote an opinion which said, well, once this thing has been in practice for so long, we're not going to go back and do the right thing and redo everything. And I'm like, no. You've got to go back and take down the 13th Amendment. You can't say, well, we've been living with it for so long and whatever, because it's a crack in the foundation. It's a crack in the foundation. Sorry, you're going to have to go back. You're going to have to remove the 13th, 14th, 15th, 16th. Actually, I think pretty sure I have to go through it, and I'll show. And later in Epic, the last 11 pages are just, I did all that in the heart of the owl, Idaho. And it's just completely revamping the system as it was originally supposed to run. And we're going to head there no matter what. But we can't do Elena Kagan, and as guided by Scalia, is the one who encouraged her. It was his idea that she write this, but it's all tobacco swamp. It's all swamp BS to try to just prevent us from doing the right thing and taking down the 16th. And maybe she's got to change that attitude. Maybe for some things it was okay, but in this case, it's not going to work to say, well, we could just ignore that. And we've been living with it for so long, and slavery isn't going to come back anyway, and blah, blah. No, you got to go back. Judicial review of the amendment process has no limitations, and take down the 13th Amendment, and in the same opinion, put it under the 9th Amendment, that there is a human right to not be owned by another human. Okay, you could put it all in the same opinion if you want, but the 13th Amendment must be struck down by the Supreme Court, or you will never get respect that you need. You've already lost it, actually. You guys don't have it. But we can't. It's so inevitable world peace when that comes. I mean, it's inevitable. I'm just saying we have to get there faster. You can't go by Elena Kagan's theory that once you've been living with something for so long, it's okay to keep living with it even despite and not do the right thing. She says the right thing because it could be too disruptive to do the right thing. It's like, no, all you're doing is putting off stuff that's going to need to be done. It's going to be much more painful doing it down the line. Many more deaths, many more garbage happening. We need to do it now. So we're going to strike down the 13th Amendment, and I'm pretty sure the 16th has to come first, so we have to go reversed. And the 13th Amendment, because logic will start to set in, and this paper will start to set in then, but you have to do it. And I argue for why we do that, but it's going to be, you won't even have to argue for this because, most people will be logical at that point. The people who are being logical and smart and whatever will rise to the top is what I'm saying. And they'll just bury these bad arguments. Swamp arguments. Okay, Taney's ambiguity on whether the right to own a slave is expressly affirmed in the Constitution ran against the conclusion in the tirade. So taking no chances, this problematic paragraph was inserted to, quote-unquote, clarify Taney's ambiguity on this point. And in the process, Taney's well-reasoned argument for why the Missouri Compromise was unconstitutional was completely blurred, blitzed, and buried. Some may recognize the same techniques being used to this day by supporters of Congress in its power plays against the President and the Supreme Court. First and foremost, Taney's reputation must be smeared by strategically placed sound bites, quote-unquote, so to speak, in his majority opinion that put words in his mouth and that could be rattled off quickly to the masses to achieve the second critical goal, to make sure nobody actually reads Taney's solid arguments and conclusions. This appears to have been quite a successful strategy and hence still used to this day, since it seems I may be the first law student in over 160 years to try to brief Dred Scott v. Sandford by actually reading it. This problematic paragraph represents one of those strategically placed sound bites and is removed from the majority opinion in Dred Scott v. Sandford, without the D. The concluding paragraphs in Taney's discussion of the constitutionality of the Missouri Compromise and the following two paragraphs introducing the next issue Taney discusses, whether Dred Scott was made free by traveling to the state of Illinois, reads as follows. So, I'm not going to read them, but it flows very clearly and it's very logical. Good segue, no grammatical errors, and it follows the original outline. Issue 1, issue 2, and boom, boom, boom. You'll see it in my case brief. Okay? A few other grammatical or style inconsistencies tend to support the idea that both the tirade and the problematic paragraph referenced in the tirade do not belong in the original majority opinion. For instance, Taney only refers to Dred Scott as Scott, whereas the tirade refers to Dred Scott as Dred Scott. Taney also focuses on the plaintiff, as a Supreme Court justice should, mentioning the word plaintiff 40 times in the majority opinion. The tirade only uses the word plaintiff twice, despite being of similar length to Taney's opinion. Taney spells the word guarantees as guarantees, Guarantees, but the tirade uses a common spelling at the time for this word, which is guarantees, Guaranties. The problematic paragraph also uses a common spelling at the time for the word guaranteed as guaranteed, Tied, when it is most likely Taney would have spelled this word as guaranteed, Eed. Okay, so I did find the guarantees with an EES, but not the EED. But I'm sure if you look at his other writings, I searched other opinions by him, and I didn't do it successfully. But somebody could do it. Come on, historians. Nobody wants to do it after they want to be the first ones to discover this. Is probably what it is. It's like, I don't know. Come on, man. There's a lot of fun stuff still left to be done on this. But anyway, whatever. It's just so many people. We have so much corruption going on that the good people are just buried, and they leave the field, and they're just discouraged because only slime holes or stupid people will get advanced, I guess. Come on, you guys. Whatever. I know there's some Wordle people though who would be interested in this. I know you guys, New York Times, there's some people still there. I'm pretty sure you're talking to me. Though evidence of either spelling. Okay. Finally, whoever wrote the tirade puts a question mark at the end of sentences that are not questions, such as, the question before us is whether the class of persons described in the plea of abatement compose a portion of this people and are constituent members of this sovereignty, question mark. Okay, what? They do that a lot. And, you know what? Some of the justices did, the dissenting ones did this, but Taney never did. And here's another. The question then arises whether the provisions of the Constitution in relation to the person. This was a long one, but then there's a question when it's not a question. This was a common style that shows up in the opinions of other justices, but a cursory search of other opinions penned by Taney has yet to reveal him using this style in his writing. Okay, so here's a couple of things that still need to be done, and I don't have the tools or whatever to do it. I really don't. My cursory search is all I've done. Okay? But it would be nice to see if he ever did that. I don't think he did. And then C, baseless conclusionary statements in the tirade, in contrast with the arguments in Justice Curtis's dissent. Conclusionary, this concludes first, third. This was like, it's just conclusionary. Inflammatory, infatuation with discussing race, and I might not even cover that one. It's just, the arguments are ridiculous is all I'm saying in that part. I discuss Curtis, so I will. I'm going to read it. 1248. Maybe I will. I want to get to African 22. And then Daniel. Okay, what I'm going to read tonight to end this is really, that's a weaker one. C is weaker argument. I'm going to read the stronger argument. D. Okay, the conclusions I arrived at. This was a little bit weak, but it's just conclusionary statements mostly in the tirade. The tirade isn't well written, is what I'm saying. It's like it's written by a law school student. D, infatuation with discussing race and disparaging the African race in particular. I might go back when I continue this, because I'm not going to be able to finish this tonight. I'm going to finish this section, and then I'm going to do, maybe 7.2. No, it's going to be 8 in the series. Okay. Infatuation with discussing race and disparaging the African race in particular. That's the fourth evidence, D. An infatuation with discussing race and disparaging the African race in particular becomes evident almost immediately when reading the tirade. Arguments that it was considered acceptable to discuss race in this way in the old days is not borne out by an analysis of the rest of the majority opinion, nor an analysis of the concurring dissenting opinions. The word race is used 58 times in the tirade, but this word is not found anywhere else in Taney's majority opinion. The word race is used 10 times in the concurring dissenting opinions in Dred Scott versus Sandford with a D, but 4 of these times are in the concurring opinion of Justice Daniel, which, as discussed below, has 4.5 problematic paragraphs that were removed. Once these paragraphs are removed, Daniel's opinion in Dred Scott versus Sandford has 0 mentions of race. The remaining 6 mentions of race are in the dissenting opinions of McLean, race mentioned once, and Curtis, race mentioned 5 times, which is to be expected because these 2 dissenters directly addressed the issue of race brought up in Sandford's plea in abatement, Curtis much more so than McLean. The overuse of the word race in the tirade was therefore a valid red flag, even in 1857, that something was not right in the majority opinion of Dred Scott v. Sandford with a D. A brief synopsis of the word race in removed parts of Dred Scott versus Sandford and in the entire case of Dred Scott v. Sandford is as follows, with number of mentions in parentheses. Okay, so I'm talking about 11,000 word tirade removed, the paragraph at the end of Taney's, toward the end of Taney's opinion removed, and then there was a paragraph in Curtis. Oh, I mentioned the paragraph in Curtis removed in part. Oh, I removed that part. Oh, it was very good actually. But okay, I'll explain that other paragraph tomorrow or the next day. And then also the 4.5 paragraphs. And I put them in one section. Now we're going to analyze the difference between the two. And then you're going to say, well, you're bringing the cart before the horse, blah, blah, blah. But there were other independent verifications that these things should be removed. And then this just, added to it. This added to it. So, race mentioned 62 times in the removed parts of Dred Scott versus Sandford, including African race 22 times, white race 7, Negro race 5, subject race 3, unfortunate race 2, dominant race 2, citizen race 1, Negro African race 1, Indian race 1, unhappy race 1, unhappy black race 1, white and black races 1 time, slave races 1, and the free and subjugated races 1. Okay, compare that with race mentioned 6 times in the entire case of Dred Scott versus Sandford, including white race 4 times, and African race once, mentioned by Curtis, and colored race once, mentioned by McLean. Okay, it's always disparaging, too, in the tirade, and it's never disparaging in the real opinions. Okay? But anyway, even the word African is not mentioned often by the justices. A similar synopsis shows that, with the exception of the concurring opinion of Justice Campbell, who mentions the African slave trade in England twice, and the dissenting opinion of Justice Curtis, who mentions the word African 10 times, due to directly countering Sandford's plea in abatement, the remaining 18 times the word African is used by the justices in Dred Scott versus Sandford are to cite or repeat the words used by Sandford in his plea in abatement when the justices were just stating the facts of the case, as follows. So a lot of times, all the justices will, I don't know why they had to do this, but why all the dissenting opinions, but they'll state the facts of the case and then they'll state their arguments. And so every time African was used was, here's Taney. The defendant pleaded in abatement to the jurisdiction of the court, the plaintiff, blah, 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 being a Negro of African descent. They were just quoting something earlier so that they could, go on, that this was his argument. They're quoting his argument. Wayne, no mention of the word race. Nelson, he just repeated the arguments of Sandford. Greer, no mention of the word African. Daniel, mentioned African again, the same. They're just reproducing the African as mentioned by Sandford. African. Catrone, McLean, they're all repeating. They say the same thing. So that's all the times. So the excerpts above encompass all 30 times the word African is used in Dred Scott versus Sandford, which is over 200 pages long. And at no time was this word used disparagingly. Contrast this with the 31 times the word African, even more times, is used in the 26 fraudulent pages. So 30 times in 200 pages, and never used disparagingly, versus 26 times versus 31 times in 26 pages, and is always disparagingly or mostly in disparaging ways. A few examples of how the word African was used in the paragraph removed from the concurring opinion of Justice Daniel discussed below, which also, a few examples, here they are, which also help flag down those problem paragraphs in the first place, are as follows. 1. Now, here's a quote from the gay Nazi assholes who wrote this. Now, the following are truths which are knowledge of the history, of the world, and particularly of that of our country, compels us to know that the African Negro race never have been acknowledged as belonging to the family of nations. What the fuck? Who the fuck writes that? You really think that any justice of the Supreme Court wrote that? Really? Like, never? That's so, anyway, the correct conclusions upon the question here considered would seem to be these, quote, that in the establishment of the several communities now of the states of this union, and in the formation of the federal government, the African was not deemed politically a person. When the fuck? That so far as the rights of the immunity, this is all false, by the way, as Curtis did in his dissent, which was great, but it's like it was hitting a straw man. Maybe I should go back to the Curtis dissent first. Because anyway, that so far as the rights and immunities as pertaining to citizens have been defined and secured by the Constitution and laws of the United States, the African race is not and never was recognized by either language or person of the former. It's all bullshit. These were all removed. Like overuse of the word race, overuse of the word African, and the use of this word in disparaging ways was therefore also a valid red flag, even in 1857, that something was not right in certain isolated parts of the majority opinion in Dred Scott versus Sanford, and also the rest. And then, okay, so how the problematic sections in Justice Daniel's concurring opinion were flagged down or removed or changed back to their original meaning. 1258. I just want to see. So I go on. This was how I changed manumission. It was very brilliant what they did to change it, but it was also depending on nobody reading anything. I'm gonna go. No, it's only 1 o'clock. I should have read the weaker argument, because it flows naturally. I shouldn't skip around like that. Dang it! I wish I didn't skip around like that, because I thought that mentioning the race part was very strong. Okay, but it just flows. It's okay if it's weak. I put it up here. Let me just do this. I'm sorry. I want to go through chronologically. Okay, so it's not as strong of an argument, but I want to get it done so that I do Daniel and the other stuff later. Okay, hold on. Here's the problematic sections. A, B, C. I'm going to read C. Hold on, everybody. And then I'm going to go. Okay, so that's why that paragraph was removed. I'm going to explain why the Curtis paragraph was removed. Okay? C. Baseless conclusionary statements in the tirade, in contrast with the arguments in Justice Curtis's dissent, which was a good dissent, but okay. The most common criticism of arguments written by law school students is that their arguments are too conclusionary, meaning a statement or conclusion is presented without any argument or supporting facts as to how this conclusion was reached. The 11,000-word tirade stands out from the rest of Taney's opinion, as well as the opinions of the other justices, in that it appears to have been written by a law student, full of conclusionary statements without evidence, or, where supposed evidence is presented, the arguments are supported either by opinions that are disguised as facts. The arguments are supported either by opinions that are disguised as facts or irrelevant facts that have nothing to do with the argument, or just lies like we just said. It's never been shown to be whatever. I just read a few of them, so that's good. You saw later, so I discussed those later. But the crux of the entire argument presented in the tirade concerning Scott and how his status as a slave of African descent can never allow him to be a U.S. citizen under any circumstances is as follows. So here's the biggest piece of BS from the tirade. Pretty much. Here it is. The words people of the United States, and this is a quote from the tirade. The words people of the United States and citizens are synonymous terms and mean the same thing. They both describe the political body who, according to our republican institutions, form the sovereignty and who hold the power and conduct the government through their representatives. They are what we finally call the sovereign people. And every citizen is one of this people and a constituent member of the sovereignty. The question before us is whether the class of persons described in the plea and abatement compose a portion of this people and are constituent members of this sovereignty. And there's the question mark. Okay, there's not a question. The question before us is whether, he says whether, that's not a question, but he puts a question mark there. I hate that. We think they are not, and that they are not included. Well, suck an egg. That's very conclusionary. And were not intended to be included under the word citizens in the Constitution, and can therefore claim none of the rights and privileges which that instrument provides for and secures to the citizens of the United States. On the contrary, they were at that time considered as a subordinate and inferior class of beings who had been subjugated by the dominant race and, whether emancipated or not, yet remained subject to the authority and had no rights or privileges, but as such those who held the power of the government might choose to grant them. I think it was another run-on sentence again too. I'll have to check that out. But it's just, who the F writes that? Okay. If you believe, just not any other evidence, I'm going to read that to you. You really believe a Supreme Court justice wrote that? Like, okay, maybe you've lost faith in them because of this, but I'm just saying, whatever. It's just, okay. Most of this paragraph from the tirade is conclusionary and based on opinion rather than fact, which may be acceptable when trying to present a general outline of what the argument is about. But this style continues throughout the tirade, 25 pages of this bullshit. Okay, a detailed list of examples is not given here for the sake of brevity. Readers are instead referred to the dissenting opinion of Justice Curtis, where the general argument presented in the tirade that anybody of African descent can never be considered a U.S. citizen under the Constitution is dismissed in great detail, and with writing and argument styles becoming of a Supreme Court justice. It really was taken apart by him very nicely. This brings up the question of whether Curtis directly addresses the tirade in his dissenting opinion, especially considering a majority of his dissenting opinion seems to counter the conclusionary arguments in the tirade. However, closer inspection shows the dissenting opinions of both McLean and Curtis actually referenced Sanford's plea and abatement alone, and not the tirade. The one exception is a concluding paragraph that appears to have been inserted after Curtis had already listed out the conclusions to his arguments, that people of African descent can most certainly become U.S. citizens according to the Constitution. The problematic paragraph in Curtis's opinion, which begins with, I dissent, therefore, from that part of the opinion of the majority of the court in which it is held that a person of African descent cannot be a citizen of the United States. They never said that, people. Okay, yet this is the most quoted paragraph of Curtis. He writes a long dissent too. And the list of conclusions immediately preceding this paragraph are as follows. Okay, so it goes like this. The conclusions at which I have arrived on this part are, these are him writing this. First, that the free native-born citizens of each state are citizens of the United States. That as free colored persons born within some of the states are citizens of those states, such persons are also citizens of the United States. That every such citizen residing in any state has the right to sue and is liable to be sued in the federal courts as a citizen of the state in which he resides. Fourth, that as a plea to the jurisdiction in this case shows no facts except that the plaintiff was of African descent and his ancestors were sold as slaves, and as these facts are not inconsistent with the citizen of the United States and his residence of the state of Missouri, the plea in jurisdiction was bad, and the judgment of the circuit court overruling it was correct. So, once again, Curtis is saying that the lower court was fine in overturning that, but he's basing it only on the plea and abatement, whereas the majority says, no, you got to look at everything, including Scott's own arguments that he was a slave and that he's not free at the time. That was the main thing. Okay, so anyway, they just the Nazis just turned it around to make it look like the majority agreed with the plea and abatement, when what they're doing is they're agreeing that he was with what they're doing is they're agreeing with the state of Missouri. But I do that. I discuss that in the case brief, which is very good actually. I dissent. Here's what Curtis did not write. I dissent, therefore, from that part of the opinion of the majority of the court in which it is held that a person of African descent cannot be a citizen of the United States. And I regret I must go further in dissent both from what I deem their assumption of authority to examine the constitutionality of the act of Congress commonly called the Missouri Compromise Act and the grounds and conclusions announced in their opinions. So Curtis did a great job, saying that a black person can and will and should be a citizen. And he did a great job disagreeing with what all the justices disagreed with. Okay, let me just go on. Okay. The only other time Curtis lists out the conclusions to his arguments in this way, he does not follow it up with a concluding paragraph on top of that, perhaps offering some evidence that this paragraph does not belong in Curtis's opinion. The other part of Curtis's opinion, where he lists out conclusions that has to do with his arguments against the ruling of the Missouri Compromise, was unconstitutional. So Curtis disagreed with the plea and abatement, which everybody did, but he also disagreed that the Missouri Compromise was unconstitutional, which was the complete, it's very bad opinion. It really is. To this day, you can just look at it. Everybody would agree. So he lists things out. First, the rules of international law. These are stupid. Second, these are stupid arguments. Third, fourth, they're his arguments, but they're dumb. But they're his. Although Curtis's arguments dismissing the outrageous conclusion that Scott could never be a U.S. citizen because he was of African descent is a bit of a strongman argument, taking down an issue that none of the other justices, including Taney, in his majority opinion, bothers to even mention, it is still a very well thought out and reasoned argument, and it is much stronger than the weak arguments Curtis subsequently presents against Taney's solid arguments that the Missouri Compromise was unconstitutional. This inserted paragraph therefore appears to be another soundbite that not only helps to affirm that the tirade belongs in the majority opinion by referencing it, but it also takes the credibility that Curtis gains from this strongman arguments, taking down the outrageous arguments made by Sanford's plea and abatement and tirade, and leverages this credibility to make his weak dissenting arguments concerning the Missouri Compromise appear much stronger. This is supported by the fact that this paragraph, unlike any other paragraph in the entire case, sums up two major conclusions from 70 pages of arguments by Curtis in one sentence. Anybody looking for a quick summary of the case will dismiss anything Taney has to say because of the ridiculous tirade, including Taney's conclusions on the Missouri Compromise, the main goal of why they did this, and in turn trust whatever Curtis has to say because of his strong dissent from Taney's tirade, including whatever Curtis has to say on the Missouri Compromise. This is all summed up in this fraudulently inserted one-sentence paragraph, paraphrased as follows, quote, I dissent from Taney's ridiculous tirade concerning people of African descent, and I also dissent from Taney's opinion on the Missouri Compromise, which is just as ridiculous as the tirade, so don't even bother reading it. It's like that's exactly what happened. Despite these arguments, the fact remains that this soundbite paragraph, much like the soundbite paragraph removed from Taney's opinion, supra, probably never would have been noticed nor removed as fraudulent by me if the tirade had not first been identified and removed. These paragraphs do not break the flow of logic, at least not until after the tirade is removed, the way the tirade does, nor the way the paragraphs flagged and removed from the concurring opinion of Justice Daniel do, infra. So they are less obvious. I'm just saying the paragraphs are less obvious, and I need more, just the fact that they reference the tirade says that they should be removed. But they're also the ones that everybody quoted the most. So that's, for that reason, they very strategically and very nicely, the gay Nazi assholes doing this did exactly, they're very good at what they do. Infatuation with discussing race and disparaging the African race in particular. I just read that part. I'm sorry I read it out of order. I just thought it was, I was running out of time, which I wasn't. So the next part, and I gotta go, but it's this whole, I call it epic, is broken down into two parts. The whole part is describing how I made the original opinion what it is. And then I brief it, which is a whole other file. But then after that, I have the last 11 pages where I discuss the implications of this. But right now I got as far as, I'm going to show the last part, which is Daniel's 4.5 paragraphs. I'm going to read that on the next one. I got to go. It's 1:11. That's a good time to stop. Good number. Everything's going to be okay. Everybody hang in there. I'm living my best life for sure. And now it's 1:12. I didn't end on time. Bad luck. No. I'm not that bad. I'm not so particular. I started ending it. Godspeed to everybody getting out the other side in one piece. PEACE. All right. We're going to post this. Hopefully it posts before I get to work. I'm going to start posting it. Bye.